The tears were flowing in a Wisconsin courtroom this week as a former teacher's aide appeared to answer for disturbing sex crime charges. Stephanie Jensen, the 41-year-old mom accused of having a sexual relationship with a teenage boy, broke down during her latest hearing as she entered a plea. Not only is she accused of having sex with the boy when he was just 15, the boy told police that Jensen was allegedly, quote, flirty with him since he was 12. But the judge showed no leniency, shutting down a key request that would have changed Jensen's situation. We're on the case presented by Law&Crime. I'm Stewart. Hey guys, real quick before we get into this case, let's talk about our partner, Morgan & Morgan, great sponsor of OTC. They're America's largest personal injury law firm. They have more than 1,000 attorneys, and they've recovered $25 billion for more than 500,000 clients. In the past few months alone, a client in Florida received $12 million when insurance offered just $350,000. In Pennsylvania, another client was awarded $26 million. That is 40 times the insurer's offer. Morgan & Morgan makes it easy to fight for what you deserve. You can even start a claim from your phone. So if you're injured, you can start a claim at forthepeople.com/OTC. You can also click the link below or scan the QR code on your screen. We're following up on a story that we have been tracking closely. It's definitely a disturbing one. You'll remember Stephanie Jensen, the 41-year-old former teacher's aide who lived in Fond du Lac, Wisconsin, the mom and wife who seemed to be living a normal life until allegations surfaced that she was engaged in a sexual relationship with a teenage boy that began when he was just 15. Now, the criminal complaint that we have here at Law&Crime details multiple alleged encounters, nude photos and videos being sent back and forth, and even claims that this woman in her 40s shared explicit content with the boy's friends. This is a case that absolutely stunned the community in Fond du Lac. And this mom was back in court this week for a key hearing. And I'll tell you, the emotions were running high. She was in tears during that court appearance, as seen in these images from WLUK. But beyond the tears, a major legal decision was made in this case. Now, I have the latest on the plea that she entered and what it means for the path forward for Stephanie Jensen. And let me tell you, this story and the details of it that are in the court documents we're about to talk about, it's a lot. Picture Fond du Lac, Wisconsin. Let's start there. Quiet, quintessential Midwest town, a place where there is Faith Lutheran School. That's a small private Christian school for kids from 3 years old in kindergarten through 8th grade. And at that school, there was a 41-year-old woman named Stephanie Jensen. Social media shows that she was a wife, a mom of 2, and by all outside appearances, she was living a pretty normal life. Her job was teaching at that school as a teaching assistant in the 2nd grade. So now the story really begins with a teenage boy. According to the criminal complaint, this wasn't just some random kid that she met. Their families knew each other. He was even a student at the school back when Jensen started working there. He was in the 8th grade at the time. So she knew exactly who he was, and legally speaking, and more importantly speaking, she knew how old he was. Now, the boy, who investigators call Victim 1, told police that Jensen had been, quote, flirty with him since he was just 12 years old. Now, he described one incident at a family celebration where he says Jensen was, quote, tipsy and sat on his lap, rubbing up on him. Just 12. But things allegedly escalated wildly from there. Fast forward to when the boy was 15, and that's when he says the first sexual encounter happened. Jensen would message him on Snapchat when her husband was gone, telling him to come over to her house. And he says he did that. He told police that he would park his car not in her driveway, but in a field north of her home to avoid her Ring doorbell camera. Then he would sneak through the rear garage door, and he says their sexual encounters would happen in her garage or her bedroom. And he claims that she told him that he didn't need to wear a condom because she couldn't get pregnant. Now, even more disturbing, allegedly, is that this wasn't just a one-time thing, he says. There were multiple occasions over the years. He describes a specific time in May of this year in her garage. Then there was another time in October of this year, also in the garage of Jensen's home. He even described a brazen daytime encounter where he says they met at a Target, they kissed, and then she followed him to a public hunting land parking lot where they had sex until they were allegedly interrupted by someone who was there walking their dog. But of all the shocking parts of what's being alleged against Stephanie Jensen, this wasn't just in person, according to these allegations. The boy told police that they exchanged explicit photos and videos, and they did that constantly on Snapchat. He says that she would send him nude pictures of herself and videos of herself using sex toys, and then she would ask him what color toy that he preferred. Now, he in turn sent her explicit videos of himself, and that is key when it comes to the charges we'll talk about with which Jensen is facing. Now, even though that part is shocking, the sexual encounter is disturbing. This gets even allegedly broader, according to the boy, because the complaint quotes the boy claiming that Jensen, quote, was not only sending him nude pictures, but that she was sending his buddies nude content as well, end quote. He said word spread through his friend group that she was, quote, willing to share, so his friends would add her on Snapchat to, in their words, quote, see what I can do to her. So you have this image, a second grade teacher's aide, married, mom, allegedly carrying on a sexual relationship with a student turned teenager for years and allegedly distributing explicit material to his circle of friends. So police, they have all this information, they hear the boy's side of the story, and then they confront Stephanie Jensen about what the boy told them. And when police confront her, which happened at her home last month in November, the complaint alleges that she denied having sex with the boy, but then admitted that he sent her explicit videos. And then police say when she was asked about how she responded to getting explicit videos from a minor, her alleged answer was, quote, I don't know, I'd have to look back. Asked if she ever sent him photos with her breasts exposed, she allegedly said, quote, yeah, I don't know. Now, when they told her that she was under arrest, deputies say that she replied, quote, I am not under arrest, and she refused to stand up from the couch, forcing them to physically lift her to handcuff her. So that lays out a staggering, alleged, multi-year saga that led to Stephanie Jensen being charged with a total of 13 criminal counts. This is a story of alleged betrayal on almost every level, of trust, of her position as a teacher, as frankly just an adult, and a betrayal allegedly of the law. So after all of that, Stephanie Jensen faced a judge this week, and she made her formal court appearance in Fond du Lac County, and it was a very different scene from the woman who allegedly told deputies, quote, I am not under arrest, because these are images from WLUK that just showed Jensen in tears, visibly emotional throughout this hearing. And in that hearing, WBAY and WLUK report that Jensen entered a plea to the 13 charges that she's facing, which include child enticement, exposing genitals, sexual assault of a child, and possession of child pornography. She has pleaded not guilty to those charges. WBAY reports that her defense team asked the judge to modify her bond conditions. Now remember, she has been sitting in the Fond du Lac County Jail on a $200,000 cash bond. Her lawyers argued for changes, likely hoping to get her released or under some less restrictive terms, but it was denied by the judge. So now let's get into the meat of this, the actual criminal complaint, because this is the document where the state lays out its evidence, and in this case, it reads like a dark, twisted novel. But according to police, all of this is very much nonfiction and very much real. We're going to walk through it because the details are crucial to understanding the sheer scope of what's alleged. First, let's talk about the timeline of the sexual encounters. Now, the complaint doesn't just say multiple times, it pins down 4 specific alleged incidents, each forming the basis for a block of charges. The first time, September of last year, 2024. The victim stated the earliest sexual encounter was before his 16th birthday. He was specific. It was before he got his driver's license. The complaint quotes his account. Quote, victim 1 stated the earliest time they had sexual intercourse was in September of 2024. That was prior to his 16th birthday. They went back to Stephanie Jensen's house and they engaged in sexual relations in her bedroom. Then the second time, May of 2025. The complaint alleges another encounter sometime between May 1st and May 31st, 2025. This one, the victim says, it happened in her home, likely in the garage of Jensen's house. Now this time frame is key because police had actually received a cyber tip in May 2025 about sexualized conversations between Jensen and a minor. Conversations that, according to the criminal complaint, were about this very encounter. The third time, October 13th, 2025. This is the brazen public one by Target. The complaint details that they met at Target, they kissed at Target, then Jensen followed the victim to a public hunting land parking lot. The complaint quotes the victim, quote, there he had sexual intercourse with Stephanie Jensen that got interrupted by someone who arrived in the same parking lot that went to walk their dog on the trail. The fourth and final alleged time, October 25th, 2025. This is the encounter that seems to have blown this case wide open. The victim stated they had sex in her garage. He described a routine. The complaint quotes him, quote, police say she would take her clothes off and perform sexual acts that are too graphic for us to mention, and he would then have more sexual relations with Stephanie Jensen in the garage. That was the way most of their sexual encounters would happen. Now, for each one of these 4 alleged encounters, the complaint files a matching set of charges. That is 12 of the 13 counts right there. But the 13th count is a standalone digital bomb, possession of child pornography. Now, this charge stems directly from the digital evidence from October 25th. The complaint details that after the victim sent an explicit image and video of himself that evening, data shows Jensen's phone, quote, loved the image. That act of knowingly accessing and viewing that content, according to the state, constitutes possession. The complaint also shows a pattern of solicitation. On the same day that she messaged him, the complaint cites the messages, quote, if there was somehow you could convince me, end quote. And then, quote, come over. And then there's the alarming allegation about the wider circle. The complaint directly quotes the victim's statement to police. Quote, victim 1 mentioned Stephanie Jensen was not only sending him nude pictures, but that she was sending his buddies nude content as well. Victim 1 said word traveled throughout his friend group that she was willing to share, so people that he knew would add her to see what she would share with them. Finally, the complaint captures Jensen's own words during the police interview. When asked about the explicit videos the victim sent her, she said, quote, I don't know, I'd have to look back, which is just a bizarre thing to say. Now, when asked if she sent him pictures with her breasts exposed, she replied, quote, yeah, I don't know. And it was a long time ago, which also, just on the outside here, you think you'd remember that. It all paints a picture of a calculated, repeated pattern of abuse documented in time-stamped locations and digital messages that forms the backbone of this devastating 13-count criminal complaint. Joining us now to talk a little bit more about this case is Dan Shore, former sex crimes prosecutor. Thank you for, as always, being with us here on Law and Crime. We see Stephanie Jensen in the images that we have from her court appearance. She is in tears, very emotional. It is very different from what she allegedly told police when they confronted her with these allegations. How do you read that? Just the emotion that she has in the courtroom.
Well, first of all, I think it's important to just think about where she is in her life, that she's in a courtroom being charged with having sex with an underage boy who she had some kind of authority role as an employee of a school with, that she's facing incarceration. So putting aside whether she's guilty or not, that's a devastating moment in one's life to be facing charges like that. And I think it's very natural to have a reaction like that. So I wouldn't read too much into it about guilt or innocence or what she's going to do as a defense strategy. I just think that's just personally, that's got to be a very, very, very upsetting moment in your life to be at that point.
And her attorneys were trying to get her on some sort of supervised release to modify the bond condition. She's facing a $200,000 bond, I believe it's cash bond at this point. What do you make of that amount? Because each state, each jurisdiction's a little different with the bond that's been put down. But since she was arrested last month, she has been in the county jail in Fond du Lac.
Right, and that's often the primary goal of a defense attorney when you have a case at this stage, at the early stage, is to get your client out of jail and not have to be incarcerated while you're awaiting the next steps in the criminal justice process. So I think that bond is reasonable considering the seriousness of the charges. Usually one of the main factors is whether someone's a flight risk, whether they're going to return to court. So the court would make those kind of calculations. But in addition to just being free from incarceration during the dependency of the case, very often whether someone's incarcerated at the early stages of a case is very important for the plea negotiations, because a defendant who's in jail has a lot less leverage in negotiations than someone who's free and out and then can negotiate from a position of freedom. So it changes the calculation a lot. So there's a lot of reasons why a defense attorney would want to get someone either bond lowered or get them out of jail for one way or another.
One thing when it comes to bond, because I could see the argument that this is a woman who's, she might be from Fond du Lac, I'm not sure, but she seemed like she had ties to the community. Like she's a mom, she has 2 kids. To our understanding, she worked at this local school that no matter what happens, she won't be working there ever again. But it doesn't seem like she's the type of person that would have some connection out of state that you would be concerned that she would flee. How do, in these cases, though, the severity of the charges and the allegations that she's facing factor into the decision to not modify the bond, even if she is facing some serious charges, but at the same time, I think there could be an argument there that she wasn't going to go anywhere.
Well, the amount of time that you're facing as a potential maximum for incarceration is very relevant to whether someone is deemed a flight risk for court. And as a sex crimes prosecutor, I dealt with this issue all the time, because let's say you have amazing ties to the community, you're totally solid in the community, but hypothetically, if you're facing significant prison time, that may give you a motive to flee the country, right? Even if you have ties to the community, most people who are free are going to think, well, I don't want to walk into a prison cell for 10, 20 or more years. So if someone's facing a lot of time in prison, judges often consider that just on its own to be reason for someone to be a flight risk, even if they do have ties to the local community, because if they're incarcerated for a long time, they're no longer going to be a part of that community, and that gives someone a reason to leave.
And the last time that we spoke, it was when this criminal complaint came out, and we've talked about a lot of these cases. I don't know how often we have one as detailed, released to the public as this criminal complaint of what this victim is alleging against Stephanie Jensen, and also what police say they've found in some of the digital evidence. You've prosecuted people who have faced charges like Stephanie Jensen. What stands out to you about her and the timeline that police have laid out?
Well, one thing is that there's so much communication, nude photos being exchanged, allegedly also with other students, not just this victim, and that there's this ongoing electronic trail of messages and nude photos. So it shows that it wasn't a one-off thing, that this was allegedly, if the allegations are true, a course of conduct that makes it more severe, that could lead to more significant prison time. That goes back to what we were talking about before, that could make someone even more of a flight risk. But there was certainly a brazenness of it, that she was willing to do all this electronically. And it's less and less shocking because we see this in so many cases now, but we do wonder, why are people willing to put in a message that can be recovered by law enforcement, nude photos to an underage person, which clearly, and references to having sexual activity with them. And it shows that she really put her life in his hands. Not only was she allegedly sexually abusing a boy who was 15 years old, but she also put her freedom, her future, everything in her life, she put in the hands of this 15-year-old that, if it got out publicly and law enforcement found out, we'd be in a situation like we are in now.
I think, too, of the possession of child pornography, which is a charge that she's facing. It's just one charge of the 13 she's facing, but it's a big one. And there's part of the criminal complaint that says that once the image was sent to her that they believe to be an explicit image of this young boy, that she hearts it. And I don't know if it's an iPhone, I'm assuming it is, but like that's kind of this development in the way that we communicate, like being able to like or heart an image, probably in the last 15 years. Like I can't remember when I had a BlackBerry way back when that you could heart an image, but
you
now
could not. That's a recent phenomenon, right?
How does that legally factor into the argument that like she was in possession of this and she knew that
Right.
she had it?
Right. That's a huge aspect of this because having possession, you have to knowingly have possession, want to have possession. So if someone just texted you randomly child porn and you were appalled and shocked, you wouldn't then be arrested for possession of child porn if you didn't want it, you didn't ask for it, you didn't look for it. But someone who is not only interacting with this 15-year-old, but then receives an image of him and then hearts it, that shows that there's a welcomeness, if that evidence is accurate, a welcomeness to receive it. And that speaks volumes about her intent, not only to receive it, but to keep it there, to encourage him to engage in other activity, whether it's in-person sexual activity or sending other images. So we do live in a world where intent and criminal liability can be based on hearting an image like that. And if she's going to say, well, he sent it to me without my consent, I didn't want it, she'll have to explain why she did heart it, because it sounds like a minor thing, but it's significant in terms of showing her mind frame at the time.
And I think too, and I mean, just like getting into the mechanics of like the iPhone is like to heart something. Like it's not just like, oops, my finger hearted this by accident, like maybe on Instagram if you're going through, but like that's like like there's a couple steps like just to do it that it seems it's hard to accidentally like something. If that was going to be their argument, we'll see. On the child pornography part, because she's facing 13 charges total. A lot of it seems to hinge on this boy and his account of what happened in her garage, he says, or in their home when they had sexual encounters. But you still have this one charge with what appears to be really solid digital evidence. Even if everything else is proven not to be true and you still have that one charge on her, I mean, that still, it seems, would be something that could put her in prison for a good amount of time.
Right, and it also is a charge that doesn't, as you alluded to, doesn't require the cooperation of the victim here. That when I prosecuted child sex abuse cases, and the most challenging part of it was gaining the cooperation of someone who's underage, because for very understandable reasons, parents don't want their children to have to testify, to face the person again. So, it could be re-traumatizing for anyone, even an adult, but especially for a child. So there's a lot of reasons why children may not be a part of a prosecution like this, but having possession of a child pornographic image, which she allegedly had, and then showing intent to receive it and keep it with the heart, that is as long as they have that digital evidence, which they say that law enforcement says they do, you don't need the testimony of anybody else, because just merely having that on your phone and acknowledging the receipt of it in a positive way, that's illegal. And that's a major, significant crime that could lead to significant prison time.
She's pleaded not guilty. She did that during that emotional court hearing, which isn't a surprise, I think, especially early on in this process. But if you were a prosecutor and you know you have that 13th charge, the child sex abuse material charge, and you have this evidence of her hearting this image, how does that factor into any sort of plea negotiation that goes on, knowing that you have that chip, even if without it, it seemed, her defense could theoretically argue that she's just being accused and that there's no evidence that any sort of sexual encounter happened.
Sure. Well, that's extremely important for the prosecution, because the negotiations over sentencing, if you're negotiating a plea agreement, is largely based on expectations and what the prosecution expects a sentence to likely be, what the defense expects, and then you try to meet in the middle. And there's different reasons for a plea bargain. One is to spare everyone, and especially the victim, having to go through the process. But if there's a minimum based on that child pornography charge that the prosecution thinks, well, she's at least going to get convicted of this and serve, a certain amount of prison time for that, that's going to be the bottom line. The bottom of the plea negotiations for the prosecution. They're likely not to offer a plea agreement below that. So that's going to change the calculation. And as I said before, another factor is whether the person's incarcerated already. That should not legally be a factor in plea negotiations, but in the real world it is, because someone who is out of prison free is less likely to agree to a sentence of walking into prison. If someone's already serving time and some of that time counts for credit by the time they have a plea agreement, then they're more likely to plead to some kind of prison time. So those are some of the factors, but knowing that there's one charge that seems especially solid from the prosecution is going to embolden the prosecution to be tougher in their plea negotiations if they want to.
And I just think, I know we've talked about a lot of these cases, and it's just, it's absurd. Like when you read through these allegations that this is not some novel that, And I know you write, fiction that's based on the reality of what you've seen, but it's just when it is nonfiction like this, allegedly at this point. And how do you explain like the intent and how someone who seems to be living this normal life, she's working as a teacher's aide in a second grade classroom, she's married, she's got kids, is then at the same time allegedly having this sexual relationship with someone who's 15?
Right. So in my experience, both as a prosecutor and now investigating sexual misconduct for schools and other organizations, most of the people who commit sex abuse are people who are trusted. So we have this image in the media of protect your kids from, the van that's going to pull up outside their playground and offer candy to the kids and sexually molest them. That's just not how most cases present. Most cases of sex abuse that I've handled involve someone in a trusted position like a teacher or a religious figure or a sports coach or a relative or a neighbor. And I know that's even more scary for people because you want to trust the people you trust. But the reality is most sex abuse of younger people involves grooming over a long period of time. And the people who can do that are people in a position of trust, such as someone who is an educator or works in the education field. So this is how most or a majority of sex abuse presents itself, even though I think the media often shows it more with the dark alley or that, the van person offering candy, that kind of thing. But that's just not the real world in my experience.
And when it comes to the school, so she worked at this private Christian school in Fond du Lac. They've denounced her, and she is no longer a teacher there just based off the allegations that she's facing. It's unclear if anybody in the school knew, but like how does, from the civil side of things, and there hasn't, to my knowledge, been any sort of lawsuit that's been filed or that possibility come to light as of yet, but we do see schools often face lawsuits. What would make a school liable for employing someone where seemingly this was all done out of sight of the people at this school?
Right, and that's often what I'm investigating now. I work a lot with colleges and universities and K-12 schools investigating matters like that. And a lot of it is based on what a school knew or should have known. So was someone in the school, especially an authority figure, aware of suggestions there might be sexual abuse and failed to investigate it, failed to do something, failed to separate them? Then that could open up liability for a school. Or was there something in someone's background when they were hired that was ignored or not found? That could open up liability. But if someone is applying for a job and they haven't been convicted of a crime or sued civilly, or they didn't put something offensive on social media, often an employment background check is not going to be able to find anything negative about them. And so there's only so much you could do in a background check. But historically, we've seen a lot of scandals where organizations, religious organizations, schools knew about ongoing sex abuse and did not take meaningful steps to stop it. That, just told someone to stop doing what they're doing, but didn't really remove them from the school, or didn't have any discipline, or didn't have the right policies in place. So those are the type of things that lead to potentially massive civil liability. There's nothing publicly suggesting that in this case, but I'm sure the school is going to have their own, hopefully, external investigator look into that independently and figure out if there's something to be more concerned about.
And going back to us talking about just kind of the difference between, nonfiction and fiction, because, in this case, they're allegations, but it feels like this was written as a novel. You write novels based on your career. Open Bar is a new book that is out right now. Where can people find it?
Sure. So Open Bar is a novel about a high-profile scandal relating to sexual misconduct, and it's based on my experience investigating those matters. People could go anywhere. The books are sold, Amazon, elsewhere, or they could find me on Substack to learn more about it. But I think the best fiction is based on real life, and it's authentic because these stories, as you said, are just shocking, and they're interesting for us to understand, and also hopefully they help us prevent these cases in the future if we understand how they happen, how they develop.
Yeah, because for as shocking as they are, I just think the warning signs that people see of how this stuff comes to light, because it is real life. It's really important to have a focus on it. Former sex crimes prosecutor Dan Shore, it's always great to have you on Law&Crime. Thanks for being with us.
Thanks, Chris. It's always good to talk with you.
That will do it for On the Case, presented by Law&Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.